today we know about the mistake of fact. Sometimes an offense is committed by a person inadvertently. He neither intends to commit an offense nor does he know that his act is criminal. He may be totally ignorant of the existence of relevant facts. The knowledge of relevant facts is what really makes an act evil or good. Thus, if a person is not aware of this fact and acts to the best of his judgment, his act cannot be called evil. Under such circumstances, he may take the plea that his acts were done under the misconception of the fact. Such a mistake of fact is acknowledged as a valid defense in Section 76 and 79 of IPC. Section 76. Act done by a person bound or by mistake of fact believes to be bound by law. Nothing is an offense which is done by a person who is or who by reason of a mistake or a fact and not by a reason of a mistake of law in good faith believes himself to be bound by a law to do it. Illustration: A soldier fires on a mob upon order from a superior. In conformity with the command of the law, he has committed no offense. An officer of court of justice, upon ordered by the court to arrest Y after due injury, believing Z to be Y, arrests Z. He has committed no offense. Section 79. Act done by a person justified or by a mistake of fact believing himself justified by law. Nothing is an offense which is done by a person who is justified by law or who by reason of a mistake of fact and not by mistake of a law in good faith believes himself to be justified by the law in doing it. Example is, A sees Z doing what appears to be a murder. A, in the exercise of the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murders in the act, seizes Z. In order to bring Z before the proper authorities, A has committed no offense, though it may turn out that Z was acting in self-defense. Difference between Section 76 and 79. The only difference between Section 76 and 79 is that Section 76 is a person believes that he is bound by it to do a certain act, while in 79 he believes that he is justified by law to do it for a certain act. For example, a policeman believing that a person in his senior officer and upon that person's order fires a mob. Here, he is bound by law to obey his senior officer's order. But if the policeman believes that a person is a thief, he is not bound by law to arrest the person, though he is justified by law if he arrests the person. To be eligible in either of the sections, the following conditions must be satisfied. Number 1, it is a mistake of fact and not a mistake of law that is excusable. Number 2, the act must be done in good faith. Thank you.